Okay. There'll be a lot more people coming in as they come in. I just press resend. Okay, we'll just start anyway. As they come in, we'll just make a start. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Brothers and sisters, ladies and gentlemen, welcome to another session of Islamic courses. This time it's a book review discussion, Law, Empire and the Sultan, Ottoman Imperial Authority and the late Ḥanafī Jurisprudence. Very honored and privileged to have the author, Dr. Samy Ayoub from the University of Texas in the US of A, and it's hosted as usual by our friend and ustad, Dr. Yakoob Ahmed from the Young Ottomans Foundations, www.youngottomans.com. Without further ado, I'm going to hand it over to Dr. Yakoob, but can I just remind everyone, it is being recorded. Just leave your email address if you're not on our mailing list, and if you're going to see it later, as most people do. And finally, keep your devices on, on silent or mute, whatever it is. And there is a Q&A session. So over to you, Dr. Yakoob. Assalamu alaikum, Dr. Ayoub.
Okay, so assalamu alaikum everyone. Once again, welcome to another session. We had so many of you yesterday, and we go again. The format will be a little bit different today. So what I'm going to do is I'm going to let Dr. Samy give a little introduction in terms of his work in that sense, and then we'll kick into the conversation later. Unfortunately, we are restricted for time, so today we're going to have to be very disciplined in regards to time because many of us, as you know, have things to do, and Dr. Samy is very busy at this moment in time. So without wasting any more time, Samy, if I just throw that to you and you may begin. Thank you very much.
Thank you so much, Yakoob, for the invitation, and Mizan for all the logistics, and Islamic courses for the invitation. So I'm going to share a PowerPoint with you. I'm going to go through it quickly. I'm going to jump immediately to the key argument in the book, and I'm much more interested in the questions and the engagement with the book. So let's do that. So I'm going to now share my screen here.
You should be able to share your screen now.
Fantastic, and should play. So very nice. So the image on the cover of the book depicts Sultan Suleiman the Magnificent, ruled between 1520 and 1566, while legislating in the Topkapı Palace in Istanbul. And it is.
Samy, just to intervene, we can't see anything on the screen.
Oh. Okay. Let me stop sharing. Because I have two screens, I sometimes get confused.
That's fine, no worries.
Okay, you know what? The PowerPoint is not going to be important. Let's just focus on the argument and then have conversation. So my book makes two key interventions with regard to the emergence of what I call a late Hanafi tradition and the changing nature of Ottoman Sultanic authority in the process of lawmaking. The contention of the book is that an analysis, a deep analysis, careful analysis of Islamic law and society on the basis of a supposed epistemological conflict between law and imperial power is simplistic and inaccurate in the Ottoman context. Instead, I propose that Ottoman jurists and late Hanafi jurisprudence in particular viewed Ottoman imperial enactments as authoritative and legitimate expressions of power. Late Hanafi jurists affirmed that Ottoman subjects were morally obligated to obey the Sultan. However, they stressed that this authority was not absolute and that its validity was contingent on its meeting objective of the Sharia, such as fairness and justice. The incorporation, so the ways in which that I go about this argument, that I went through key Hanafi authoritative works, whether it was legal commentaries, legal manuals, and fatwa literature, and specifically a genre that I think has been suppressed in the literature, that is the Rasail. This is the legal treatises, in which we find significant references to to Ottoman Sultanic edicts in these works. But the Ottoman Sultanic authority in these works are not only given as a reference, rather it has a function either to settle a juristic dispute or give a final reference point when it comes to policy considerations for the empire, and so on and so forth. So the book studies Hanafi legal works from the Ottoman world, specifically from the Arab provinces, from the 16th to the 19th centuries, casting new light on the understudied late Hanafi jurists. The Arabic term is al-muta'akhkhirun. Specifically, I interrogate the Hanafi tradition's portrayal of the Ottoman political authorities and their local actors and agents, such as local officials, governors, judges, and so on and so forth. All of these come to these positions because of their connection and their taking a position in the Ottoman bureaucracy, basically. So I incorporate empire as a mode of governance in the contestations about Islamic legalities during Ottoman rule. I analyze reformulations of Islamic law in the Ottoman Imperial context and their lasting legacies in the local and regional domains. So the approach, so this approach expands the legal sphere for different analytical potentialities and relieves the Islamic legal space from the burdens of the ideological baggages and presumptions when we study law and society in the context of a nation state, for example. Empires differ from nation states as political entities. Jane Purbank and Frederick Cooper, in their famous work, explain that the concept of empire presumes that different peoples within the polity will be governed differently, end of quote. So I propose in the book that late Hanafi jurists, in fact, consistently included Ottoman Sultanic edicts in their juristic discourses. I identify two ways by which Hanafis include some of these official enactments by the Ottoman sultans in the fiqh books. So something very important here is, about this particular book. So I'm not here looking at history works. I'm not here looking at anecdotes that has been written in some literature. I'm looking at what Hanafi jurists, what Muslim jurists in the madrasas read as authoritative legal texts in the Hanafi school that has been handed down from one generation to another. So this is a serious legal enterprise, is multi-layered, is authority-bound, requires all sorts of, knowledge, connections, and so on and so forth. So here I'm looking at a particular genre, that is the fiqh literature, and the fatawa and the shuruh and the matun as part of that literature, and I try to identify in that type of literature how they try to engage with the Ottoman Imperial edicts. We have plenty of historical records from the Mamluk period, for example, and even beyond, in which the Abbasids or the Mamluks and so on and so forth did intervene and have all sorts of issues dealing with the Muslim jurists. My intervention with that book is trying to say something different, say, look, when we look at the Islamic law, the fiqh tradition, Islamic jurisprudence in that later period from the 16th to the 19th century, we find, not suddenly, but we find very visibly that the Ottoman sultans come very visible. They have a role. So, and that's, I think, my hopefully contribution to this conversation. So the idea that Islamic law somehow exists outside of the state institutions or outside of politics need to be challenged in the sense that that is always either there's a kind of a meta narrative that Muslim jurists and somehow the Ottoman or any sultans, any kind of the political power has always been in tension or conflict and so on and so forth. I'm trying to say that that narrative is not helpful. Number one, empirically difficult to maintain. And number three, that we can have evidence to the contrary. We have Ottoman sultans and the Hanafis engaging each other. We have lots of back and forth. The Hanafis take some time, some of these things, accept them, adjust with them, and sometimes reject some policies that seems to be in clear violation of what they seem to be fair and justice. So, so this is really the kind of the overall argument of the book in that point. The last point I'm going to make is that the reason I focus on the so-called late Hanafis or al-muta'akhkhirun, because that late tradition, it seems to be, at least in my own reading of the existing literature, is that there's a, I think, lack of recognition that there's a different synthesis, there's a different type of identities, there's a different type of groups and networks that they call themselves muta'akhkhiri al-Hanafi, that they came to articulate the norms of the Hanafi school in a different direction. And they had different commitments and different positions on so many things. The issue is that what makes somebody a Hanafi in the 16th and 19th century versus somebody who's a Hanafi in the 10th century or Iraq or early Islam is we have, number one, the historical distance, and number two, the re-articulation of the school to reflect, number one, the change of society, the change of time, and the norms that they need to develop to change society. If you think law is connected to how society function, and if you understand law to be intimately reflecting how a normative value, set of values can govern Muslim societies, you have to understand that Islamic law has to change. And so this is not an argument. This is naturally has to be in the background of those who try to understand why late Hanafism as a tradition developed in that direction. Anyway, so I say that even late Hanafis as a label is not all. So that's not my own term or label. Rather, this is how they identify themselves in the literature. So they say, أجمع المتأخرون, the late Hanafis agreed upon. اختلف المتأخرون, طائفة من المتأخرين, بعض المتأخرين, اختيار المتأخرين, جماعة من المتأخرين, المختار عند مشايخنا المتأخرين, الشواذ المتأخرين. So that label متأخرين refers to a particular type of set of identities and a set of group and networks and texts that came to sustain that tradition in that later period. Anyway, so I will end by saying something very simple. So some of the reviews of my book, I think, try to take my argument to be an overstatement of what's happening in the Ottoman context is just a part of the siyasa, and this is just the same thing that exists historically. I'm not denying that the Ottomans were engaging in the siyasa, so the political authority of the Muslim ruler to enact some kind of policy considerations to run and govern Muslim societies. I'm not denying that. What I'm trying to really qualify is that change and the inclusion of Ottoman Sultanic edicts in the fiqh literature takes the Ottoman Sultan to the domain of legislation, not just in the kind of domain of policies when it comes to siyasa. Siyasa in the Hanafi tradition specifically has consistently used in the context of punishments, in the context of dispensation of justice, not for legislation purposes. When we see the Ottoman Sultans come in the fiqh tradition, making positions, specifically when it comes to, again, Ottoman policy considerations about bayu abid sabahiyya. So these slaves that used to be part of the Ottoman army, they've been escaping from the army. The Ottomans banned some of these things, some of these practices. Issues with regard to man'u tajweed al-saghirat, kind of prevention of kind of Ottoman edict that no one can marry young girls, especially from their immediate family, especially if you have some sort of oversight authority over their own money. So the Ottomans started to really state and intervene in that way to have policy considerations guided by their understanding of the general maslahah, the general public of the Muslim community, and not necessarily go into domains of ibadah and so on and so forth, but rather they have become much more active participants in that regard. However, I do not see the Ottomans somehow passively intervening in the fiqh and just the jurists letting them to do that. I'm saying that this is an active, the Hanafi jurists doing this and including this in their own fiqh literature is an understanding and an acceptance on some level of the indispensable nature of the Ottomans for any sort of ability to bring Islamic law to that social level. So it's not like the state is kind of coercing the Hanafis to accept their position, but rather is much more negotiating synthesis in which Hanafis accepted on some level how the Ottoman sultans are engaging legally in the empire. I'm going to stop here and look forward to your engagement. Thank you so much.
Of course. Thank you very much, Samy. And actually, that introduction was exceptionally helpful in many ways because it sort of helps me set it up to some degree. So one of the key things that I found in the book that when I was explaining to my own students is this key juncture you talk about late Hanafism, which is interesting because you make the case that they see themselves as muta'akhkhirun, and so forth. But there is a distinction in their own minds, but also an attachment to the past in some sense. And I think a lot of students my students found difficult is this idea of late Hanafism is to some degree a change, a shift, a moving away. And this moving away has happened from due to an imposition, either a Western imposition, which you talk about in your book, which we can address later, or as you mentioned, the Sultanic imposition or the imposition from the center. So I was wondering if you can actually address that question of, what is this term of late Hanafism actually encompass in that sense?
Very nice. So historically, the term late Hanafism is not really defined as clearly as articulated. But rather, we are told that early Hanafis are those who met the founders of the school, Abu Hanifa, Abu Yusuf, Shaybani, Zufar ibn Huzayl, and the late Hanafis are those who do not meet them. We have other opinions. So if you read, for example, Al-Laknawi, he says, well, late Hanafis are those who start with Al-Halwani, kind of 10th century and so on and so forth. I can accept all of these iterations, what late Hanafism might look like. But if you look at the actual references to the Hanafis themselves, so here I try in the book to really kind of present a self-centric perspective of how Hanafis try to speak on behalf of their own on their own kind of interests, how they want to present themselves, and try to hopefully try to guide the reader in that direction. So the label is not imposed by anybody. This is how they try to identify themselves. Second, in terms of a change, again, part of the challenge that I think contemporary Muslims have difficulty to understand how the mazhab function is because of lack of its existence. In the sense that somehow Muslims today have difficulty to understand, how the mazhab function. And my question is, why you ask this question unless you actually understand, or what's available is not does not really rise up to the existence of actual madhab living and can have authorities from one generation to another. So part of the problem is the historical distance of how these things used to function in reality. And the second part is that change is inevitable. This is how law functions. This is how Muslim jurists deal with these issues. So it's not imposed for sure. Number two, this is how they choose to speak about in their own affairs. So these labels are not imposed. And the last thing I will say is that the late synthesis of the school is not about denying the past. So some problems, especially by when we study late 19th, 20th century Muslim modernists and Muslim reformists argument, they trash the late not Hanafis, just anything late. Muslims in the later period became also this narrative of decline and rigidity and so on and so forth. I see these claims really, again, it's okay for them to try to criticize some of their own contemporary issues, but the issue is that early is always better will get you in trouble. Why? At Al-Azhar, there was some famous reformer. He said, well, we need to get rid of the late Hanafis or this late articulation of the school because it's rigid and so on and so forth. And let's go to the early books. You know what? And they have done that. And they printed the early books for people to study. However, they discovered something very obvious. These early books has nothing to do with the society in which we live in today. So the social context in which these early norms had been articulated has nothing to do with 19th century Egypt. Rather, the al-muta'akhkhirun has this these issues have been discussed in the literature. So for me, the trashing of the late articulation has to do, I think, more with that these type of genres, these type of legal writings are no longer generative of the type of knowledge and type of arrangement needed for the new political project in the modern nation state. And less about, these guys read hashiyas and the hashiyas are difficult. Well, okay, sure, hashiyas are for specialists. If you'd like to study that's what you need to read. If you're a judge, you have to actually do something different. But again, the historical distance in which Muslims don't understand that all these things had its own people, understand them, layered. Anyway, I think I'm gonna stop here.
No, I actually feel free to continue whenever you want. Actually, I like this idea, this notion you've mentioned of historical distance. It's an interesting one in sort of explaining the sort of like imagination or loss of understanding of the particular past. And I think that's a very pertinent point. What I wanted to know is when you've tried to challenge this narrative in your work, is this because this is now the trend in Ottoman studies at the moment, or is this what you specifically saw in the text? And the text told you, you know what, actually, what the narrative that I have accustomed to and what the text is saying are two different things.
That's a good point. I'm not sure. I think actually my narrative was against some of the existence, I think, much more prominent readings of that time period.
Right.
Look, I'm not saying that the modernists were wrong or somehow the late people are better. All I'm saying that these, I think what's missing in that conversation is the politics of the reformers. We only know something about all these guys who were rigid, blah, 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 and not really kind of reforming as fast. But we're also missing on the politics of the reformers and why they're pushing that narrative. Well, they need fast change, but not any change. They need top-down approach to change, not just that. Look, if you like to change a position, so some people say it's difficult to change a late position in the Hanafi school. Obviously, look, any legal structure that's very mature by the late 19th century, like any conservative legal structure, to change a legal position is slow. Number one, requires not just somebody who is smart legally, requires an argument that's been supported analytically, legally, politically, and socially. And then the change happens. They're not interested in that. That will take time. That we need, again, especially if you operate in a crisis mode, all of this seems to be collapsing around you. So I guess I'm just trying to give much more texture to why some of these arguments win and others don't, and why we need to be careful and pause a bit about, look, any one understanding how legal schools, how Islamic legal schools function, we understand why these layers of authority exist. There's a reason for them, and require a particular type of understanding of the context that were embedded. Politics is also part of that. Muslim jurists had no problem collaborating and having all sorts of privileges as part of the Ottoman Empire. And that's perfectly fine and should be no surprise. But to claim that somehow Muslim jurists exist outside of politics, I think we're going to run into a problem, because once the madhahib, the idea of that the madhab is no longer relevant, I think has to do directly with the lack of the political cover that used to be given to them. The political elite and legal elite saw Muslim jurists, saw the madhahib to be important for the social fabric of society. Once that's gone, I'm not sure that you actually can have any existence anymore. You literally have no position as a judge, literally have your knowledge is not relevant to the type of things that's happening in your society, and I'm not sure how you sustain in a living anymore. And people get surprised. Again, surprised because the argument that somehow Islamic law exists outside of politics will get you in trouble. You're going to get into I think a situation that you're going to regret some of these syntheses.
Yeah, I mean, what I like about your book in some ways is that, as you mentioned, especially in academia, not only in academia, in fact, that this modernist trend, this series of victories by modernists and reformists in particular, is the meta-narrative in regards to Islam in the late Ottoman period in particular, or in the world at the time. And here what we're seeing is, if we can call them that, a traditionalist notion of it being robust, having the ability to adjust, make the changes and adapt to the period at the time. And I think that for me was a very interesting takeaway that I took from the book, which is a narrative that's often missing, right, in that sense. And I think that was a really valid contribution in that sense. One of the other questions I wanted to ask you, because I spoke to Guy Burak last week, and then you mentioned in your book this idea of the state-madhhab. You challenged this idea, which he put forward last week in terms of his work, as this idea that the Hanafi madhhab is the state-madhhab. And you found that as a bit of a contradiction. I was wondering if you could elaborate on that, because that's an opinion that has stuck with many people when they think of the Ottomans and the Hanafis in particular.
Thank you. So I have no problem with the concept of state-madhhab if it's understood that it was the administrative school of the Ottomans chose to run the affairs of the empire. However, I have a problem with the term if it's used to understood that the Ottoman state completely took over the Hanafi school, or somehow the Ottomans now suddenly, or the Ottoman Sultan now suddenly have more powers than used to be, just because the Ottomans, just because the Hanafi school, because the administrative school of the empire. I don't think that the latter is sustainable, empirically or historically. But the idea of state-madhhab is true, that the Ottomans saw the Hanafis much more malleable, flexible, at least in their own understanding of how to run things in the empire. And that also brought so the book by Kenneth Kono about marriage and divorce in Egypt tells you that some of the problems in which, look, the Ottoman synthesis in Egypt, that they allowed a head judge to be the administrator of the entire judge system, and we have all sorts of legal schools and all these deputies in the provinces to run, until Muhammad Ali came in 1804 or 5, and then he officially made the Hanafi school to be the exclusive legal school in the entire Egypt. that caused a problem because Ottomans understood you cannot really force everybody to be to follow the school. Number one, issues of triple divorce became an issue. Issues of the mafqud, issues of these soldiers in the Ottoman army that used to go to wars and never go back to their families or their wives. So how many years that the wife can get married and so on and so forth. So Hanafis have all sorts of issues that might cause social problems in the context of Egypt, for example. So I think my point is that there's also different spheres and different contexts of how the Hanafis intervened in the empire and how the Ottomans chose to go about certain things, and how the provinces, once started to have some type of autonomy, messed up some of that, and dealt with that in different ways and have all sorts of consequences. I think my last article about casting off Egyptian Hanafism, about triple divorce in Egypt, tells exactly that once a legal school became the official school in Egypt, you have now Hanafis have to face lots of problems, because Hanafis used to delegate these issues to the Malikis. They used to have an easier way to divorce, and some other things about contracts to the Shafi'is, and so on and so forth. So things, again, legal pluralism was no longer desirable, unfortunately. Legal pluralism was conceived to be, oh, these guys have all sorts of legal schools. This is confusing. Well, confusing to who? Again, who is saying these things, and what interests these guys bring? We learned in Egypt that the people who pushed for the Hanafi school to be official school are actually merchants, right? Okay. So they have certain type of commitments. Anyway, so state-madhhab means different things. I'm only commenting on the particular meaning that the thought needs to be criticized.
Yeah, another point I liked in your work was that when we look at the modernists in particular, this idea that Taklid, or these people like Taklidis, became a form of criticism as a slur in society. And yet from the legal perspective, when you look at the notion of Taklid, and you use the idea of legal scaffolding, this idea of making the case that Taklid, while we can critique whether the Ottomans in the legal schools are doing ijtihad or not, but Taklid has a transformative ability. It has an ability to actually, remain relevant. And I was wondering if you can explain that, because even today we hear these terms, these people are Taklidis, these are blind followers, and it's used in a very pejorative sense. And yet in the legal text, I think this is important.
That's true. I think Muslims need to be challenged on these fronts. Taklid is ijtihad. You cannot be somebody who's a follower of a particular legal school without having a decent sense of what you're actually saying, right? And if you're going to introduce, again, late Hanafis disagreed with the founder of the school on so many issues, not because they see them, again, to be a jurist is not just because you're smart. It's not just because you're legally trained. It's, again, to be a lawyer. So if you've been, it's funny I say this. So when I teach in law schools in Texas, for example, I actually have much more productive conversations about Islamic law than when I teach in the humanities. In the law school, I enter the room or the building. Everybody there understand what law is, understand what it means. They understand that it's authority-bound structure. No one is there just because of their own opinions. You are there because of tradition that you try to articulate for the modern purposes. In the humanities, everybody think, oh, law is just everything. So guys, look, we can critique law. We can critique how law does with social law. Law is not everything, number one. Number two, you have to understand that Muslim jurists are operating with one of the most sophisticated legal traditions, have massive weight behind them. So if you imagine them to somehow overnight produce an argument that you like, it doesn't make any sense. He must make an argument, number one. It is not like just things change, we have to change as well. That argument has to be meaningful, has to have social relevance, and in a direction that tradition supports. It doesn't really work otherwise. Anyway, so Taklid requires ijtihad. It's impossible without it. And ijtihad so somebody on their own have their own opinions. Well, I'm not sure if Muslims necessarily have to follow that guy. We have, again, in my last article about the divorce case in Egypt, Mahmoud Shakir, the famous judge, and so on and so forth, in his capacity as a judge, again, as a Hanafi judge, as he claimed, he goes against the synthesis of the school to has his own opinion, and so on and so forth. His opinions, of course, was kind of reversed in the appeal decision, and basically he was told that we're not interested in your own personal views. We're interested is you are, again, because Muslim judges, again, in America, conservative judges will always tell you, okay, that we're not interested in somebody's discretionary opinion about what the law is, what the law is. You are coming from a tradition. You try to articulate it for us, and you're not just functioning haphazardly, ad hoc, based on interests that is not told to us. You work through the law. The law comes from the legislators. This is the Congress, and the judges have to abide by that. However, Muslim jurists have an exception. We expect them to be outside of the school completely. We expect them to be discretionary. We expect them to do arguments on the fly. This is not discipline. This is not how law has been done. This is not, again, if you study law in America, this tells you, this is not a judge. This is somebody who has positions on things. I'm not interested in them. You cannot force that on people.
Right. No, and yeah, I mean, that's a thing that I did pick up in your work, this idea that the jurists would have to make the case that they belong to a school is from a framework of authenticity, a framework of belonging, a framework of saying that we are still committed to a particular project and we're not thinking ad hoc from ourselves. And that's the necessity, that the framework becomes that sort of like representation that this judge in particular is not just making up the rules from themselves, but it's bound in a tradition. And I think that's a valid point that you put in your book. I wanted to go back to the question which we briefly went across, which was this, and I'll break it down into two sections. The first narrative that you challenge is Westernization, which is very common in late Ottoman studies, especially regarding Islamic law and the Majalla, which we can talk about later. And then the second thing is obviously the power influence in Hanafism. So if we can look at the idea of Westernization, which is a very common trait that we see, that for Muslims, I guess, to some degree, that there is a need to explain the sort of like collapse of the Ottomans from this framework that is an imposition from the West, and the Ottomans and Muslims in particular across the domains had somehow abandoned the integrity of Islam because of an insecurity regarding the West. And as a result, we see projects like the Majalla coming about. How would you address a question like that?
So this is a complicated question. So the Westernization thesis has to be understood kind of on a case-by-case basis, but also in the historical context that we're dealing. In my last chapter in the book, I speak specifically with regard to the Ottoman Majalla, or they used to call the Ottoman civil law, or the Muslim civil law, and so on and so forth. And it was a codification of the Islamic commercial law books from the fiqh tradition. I'm putting them in one single work. So, and the Majalla, so in my book, I attempted to do a couple of things. Number one, to acknowledge that the Ottomans were under immense pressure. European laws had to be felt at the heart of the empire. Capitulations became very much hard for the Ottomans to ignore. Most of the international trade now has been done through international law and relying on foreign laws, and so on and so forth. So there's no denying of that. But the Majalla as a product, I think is that hybrid kind of situation. Number one, the Majalla has been justified completely as an Islamic project generated from within the Muslim tradition to respond to the challenges that European and Western law is presenting to the Ottomans, specifically to applied in the new court system that the Ottomans created. It's called the Nizamiya courts, in which these judges are most of them are no longer now. They have some nominal training in Islamic law, but they're not the usual fuqaha or the usual jurists that kind of trained in the madrasas and so on and so forth. So empirically, there's serious change going on. There's a creation of a new institutions, and the choice was either to completely get an alien codes and structures, or try to have something else to kind of inspire some of these changes. Ahmed Pasha, I think one of the most important figures in that time period, was an Ottoman official, also a judge and lawyer, familiar with Islamic law in some respects. He chose to include and rely on Islamic law for that, specifically the Hanafi tradition. So my argument was, look, if you look at the content of the Majalla, is obviously a faithful synthesis of late Hanafi school in terms of its doctrines, in terms of the things that introduces and ideas and so on and so forth. In terms of its function, this is new. This is something that didn't exist before in terms of the codified Hanafi jurisprudence. that became now the official law of the Nizamiya courts. So, so again, the answer is compounded. It depends how you look at it, but it's not either or. And I think Muslims have to understand that nuance with these things is a must. You cannot just ignore or the context in which these guys were operating, or completely dismiss it as somehow Western imposition, because it wasn't either that or that. What else? So this is in general how I see that that moment. And funny thing, I'm actually right now writing something else, but also touches on something similar. The Ottoman penal code, when it comes to the issue of capital punishments. Most Ottoman literature, as kind of studies literature, mentioned that capital punishment since 1840s early on became very rare in the empire, and so on and so forth. And even the Ottoman penal code makes it difficult. You know what? The reason for something like that, most people say, just the evidentiary requirement in Islamic law makes it really difficult for people to prove something like that in a court of law. And this is still true. But the interesting thing is that these type of literature has been completely reliant on two sources, either historical records or court archives. You know what? I actually found plenty of treatises written by people around Ahmed Pasha on that subject, making arguments why why qisas, for example, should be treated like hudud, meaning yudrab b'shubuhat, and should be dropped because of issues of doubt. And that completely made any claims of capital punishment very difficult to maintain. Again, this is not part of literature. This is not being told as somehow Muslim Jews were thinking about these issues as well. It just, again, it's just the state enacting these things, and Muslim Jews somehow abiding by. We have this famous guy, his name is Abd al-Sattar Effendi al-Qirmi, the Crimean Abd al-Effendi, wrote a famous treatise in this regard, and Assyrian Jews has responded to him, and both of them had back and forth in terms of that legal treatise I was talking about. Again, so that immediately affected Ottoman policy, Ottoman penal code, and so on and so forth. So in short, again, we cannot just give a single answer, but rather it's much more complicated. There's a compounded answer. You have to be aware of all these issues around some of these issues about Westernization in general.
Yeah, and I appreciate that. One of the things as a historian myself, which is continuously trying to explain to my students the notion of nuance in that sense, and that's really appreciated. I'm realizing our time, so I'm going to just keep it brief in this sense. One of the things that I noticed in your work, you know, when you think of Ottoman Hanafism, what you think of is Istanbul. You think of what's going on in Istanbul. When you think of the Majalli, you think of the project of Ahmed or Alim Jevdet Pasha. But your work actually starts off with Ibn Nujaym and Ibn Abidin, so a scholar from Egypt and a scholar from Damascus, which is quite interesting in that sense that you've looked at it from the perspective of the provinces, powerful provinces in many ways, important provinces, both in terms of just the importance to the empire, but also in terms of scholarly work. Why did you feel the need that rather than looking at it from the center, which is what most people do in Istanbul in regards to that project, to look at, go back in time and start off with Egypt? I understand he was important, Ibn Nujaym, but why did you do Egypt, Ibn Abidin in that sense? What was the thinking behind that?
This is a very good question. I really wanted to see how Hanafi jurists in the provinces, especially those who did not have official positions in the empire, received the Ottoman Sultan's authority. Because most of the nationalist narrative that we have in the textbook, the kind of history books that we've been taught, just the Ottomans were occupiers and the Arabs, whatever, and so on, things like that. And then when you read all these jurists from Cairo, Damascus, from 1500 onwards, they have no, again, they affirm Ottoman authority of the Sultan over all the domains. They make it moral obligation on all of its subjects to actually support its rule. When a rebellion happened in Mecca, I think, so I have a piece about Ottoman soldiers in the Arabian Peninsula, in which we have 3 treatises had been written by the Hanbalis and by the Hanafis and by the Shafi'is, I believe, and the Malikis as well, wrote treatises given to the Ottoman governor in Egypt with the soldiers to go and fight this rebellion in Mecca. Those guys have no connection with the Ottoman Sultan. Maybe they heard about him, maybe just saw the governor in Egypt, but the entire treatises is an actual recognition of the Ottoman political authority. This is the president of the Muslim, this is the Sultan of the Muslims, and so on and so forth. So I really wanted to start from the provinces to just say that the Ottomans that the authority of the Ottomans in the provinces was not as militarily visible. There might not be a kind of massive military presence, but we have total recognition by the legal class of their authority and their importance and so on and so forth.
Yeah, and so one of the things I found interesting was, although this is not happening, I mean, I always felt that when you read a book, you're interacting with an author who's timeless in some ways. And what you show is, for example, Ibn Abidin interacting with Ibn Najm, but also interacting with Ibn Saud Effendi in Istanbul, right? And this connectivity of this way of this synthesis that takes place. And I wanted to ask you personally on a selfish note, because I write about Ottoman constitutionalism in the late Ottoman period, that how instrumental is someone like Ibn Abidin? We have a character here who personally, there's a lot that happens to him in regards to his influence in the Ottoman domains, but intellectually, there seems to be some sort of mark he's left in Hanafis globally, not only in the Ottoman domains. And it seems from your work that he leaves an imprint in Istanbul as well, regarding the Majelle project, with his son being on the drafting committee, his son being on drafting committee of the constitution itself, and, you know, Hanafi thought process in Istanbul. So how important was he in that sense?
I think you cannot escape Ibn Abidin if you like speak about especially late Hanafism. Ibn Abidin I think has to do with his encyclopedic nature of knowledge, his intelligence, his legal acumen. Again, there's always something about how this guy's really smart people, really committed people, dedicated their entire life to that tradition. Again, not just writing. So it was not just kind of writing. This guy had lots of interventions in the school. His works is extremely important in the imperial capital in Istanbul, in the Arab provinces and beyond, and so on and so forth. So it has to do with something like that. His knowledge, his authority, his works became immensely popular everywhere. But I think he was not really alone. Somebody like what's his name, al-Hamzawi, Mahmoud Muhammad al-Hamzawi, was extremely famous Ottoman, again, Syrian Hanafi judge, Syrian Hanafi Mufti of Damascus until 1887. And he was also the director of the endowments, okay? His treatise was just published in Darul Bab in Istanbul in 2020. And this guy, you know what? This guy was actually professional animal hunting using rifles. He knew a lot of rifles. He actually was a good hunter. He has a lot of stories about his abilities. This is the type of texture, I think, again, part of the problem we speak about Muslim tradition, Muslim jurists, that they're usually nameless, usually faceless, and we have little about their own their life and interaction with others, and we try to reduce them to a particular position in law. This is complete unfair and unjust to actually kind of bring that literature to life. We need to have something else. If you study like any American judge, actually famous, like Scalia, for example, the famous conservative judge, we know about this guy loved hunting. We know what his family, what he likes to do, what his food, loved Texas, and all these interesting things. But when it comes to Muslim tradition, we have just a couple of things, meet this guy, and nothing else.
I like this idea of yours. I was speaking to a friend of mine who's an Ottoman historian here in Istanbul, and he felt the need that there is a necessity of biographies written on characters, individuals, and peoples in the late Ottoman period as a way of bringing these people back to our imagination. But as you said, humanizing them. There seems to be an aspect when we look at late Ottoman history, going back to the point you made before, this historical distance of this dehumanization that's taken place, in particular regarding the ulama. Why do you think that's happened regarding the late ulama in particular? I mean, this is across the board, from Istanbul to Damascus to Egypt. I mean, I understand the nation state is one aspect, but why do you think this has happened?
I think the anti-clerical stand, it has to do with the emerging class. Again, I think more important for the continuation of something like Islamic law is the existence of an actual elite class of people who actually exist on the level of governance, who care about this and understand its importance for society.
Right.
Once that class was replaced by somebody else, I think whatever you say, it just seems kind of frowned upon, backward, and so on and so forth. And that position would not go away as long as, excuse me, as long as we have, again, a different type of politics that makes a balance and allow some of these things to be sorted out. Again, the ulama is one of the most smartest human beings we've ever met, philosophically, logically, and otherwise. But usually the stereotype for this again, that was the way to liberation, is just to have this anti-clerical stance and the state taken. But I think it's important that people do not have that. Once the population completely recycled in that direction, everybody became a mufti. Everybody has no really kind of regard to some of these things. And look, I'm not saying that that can be reversed. What I'm saying is there's certain balance that need to be achieved.
Okay, Samy, I'm going to leave it there for you because I know that you're very short of time, and I don't want any of the Q&As to make you go over time. So I'm going to be careful of that. So I'm just going to say thank you very much for your engagement. I really enjoyed it. And
thank you so much.
You know, I'm somebody who's, like I said, because I work on late Ottoman constitutionalism, your book has been very helpful for me in that context because I look at the role of the ulama. So Mizan, what I'm going to do is I'm going to throw this to you now. And if there's anybody who...
We've got a lot of questions. Thank you so much, Samy. So we've got 20 minutes, folks. So get your questions in or your comments as soon as possible because Dr. Samy has got class. So I'm going to ask Sheikh Sabah, please. I've just unmuted you. Sheikh Sabah from London.
Assalamu alaikum, everybody.
Walaikum salam.
First of all, I apologize. I'm not a sheikh. I also apologize. I'm not an academician. I'm a simple lawyer who practices in England. I'm a civil law lawyer by education, but I'm practicing common legal system. I am always under the impression, and this is what I keep on saying, that Islamic jurisprudence, when it began, it was based on a common legal system, whereby people would refer to Judge so-and-so said and other opinions. I think the Ottoman Empire at the time, because the Hanafi and indeed all the other Islamic jurisprudence were scattered in various sources and books and statements. And so it's very difficult for courts to actually rely on something when you don't know whether it's real or not, invented, true, exact or not. So this was probably, among other reasons, one of the reasons where they decided to collect principally the Hanafi jurisprudence. I think they've taken the Napoleonic code, the French Napoleon, the Code de Napoleon, and they've taken the contents of it as a template. So they took the table of contents and they took the issues which are discussed under this one from the various jurists. And then they had the committee which was discussing and negotiating which one of these opinions should be taken on, etc., etc. Now, maybe this sounds as if I'm making it much better than the truth, but I think this is probably what happened. Now, the second point is when we're talking about the influence of the Sultan's authority on the muta'akhkhirun, on the later jurists, I think this applies even to the earlier ones. I'm sure those people who were in the Umayyad time, the Abbasid time, they were all subject to all these things. And we actually know from history, some of them went to prison, some of them refused to be judges, etc., etc. So the influence of the state is always there, whether we look at the Umayyad time, Abbasid time, or the Ottomans. So I don't think there is anything really that much different. The other thing is this. I think Dr. Ayoub has referred a number of times to the time lag between the muta'akhkhirun and the first ones. There is so many things has happened, and you need to develop the jurisprudence to deal with the new issues. Even today, if we forget a little bit about Islamic jurisprudence under American English law and what have you, when we had the theft only dealing with somebody stealing somebody's money, now we have to think in terms of somebody stealing information from the internet. And I'm sure you have to create all these things. And this is how the jurisprudence develops. So I think I'm really delighted to, I heard from Dr. Ayoub. I was under the impression that he was being critical of the Ottomans, but then subsequently I understood he wasn't making a value judgment, he was describing the issue. Thank you very much for your time.
Thank you very much.
Thank you. Just very quickly, we don't disagree, but on the first point, I think you're correct in thinking that those guys thought that the kind of that the Code Civil or the kind of the French law as a template would be possible for them to use, and so on and so forth. For them, they argued that codification is universal, is not just really kind of unique to the kind of French code, and that's true. The only issue is that codification is not just a legal technique. I think I have to understand that the political adoption of codification has much more, has much more deeper consequences than just adopting that, okay? On the last point, with regard to the state is different from the Ottomans and Umayyads and so on and so forth, I think you're correct on one regard, and we might disagree in some other regards. Look, the Ottomans, how they run the state is very different. Again, the sophistication of governance is very different. The modern nation state is very different. But as a principle, yes, Islamic law has been part of the political process, and I think we don't disagree there.
Fantastic. We've got a question from Mark from Poland. Mark, I'm just going to unmute you now. Yalla.
Hello, thank you for your presentation. My question is, if the novum and distinct quality of the modern nation state is one fixed law for one nation, one society, and law exclusively produced and overseen by a single entity of the state, and in the Ottoman domains, we had a pluralism of societies, thus a legal pluralism and tradition of social debate when creating new regulations. I wonder to what degree the Ottoman law or the Islamic law was fixed and codified as one for everybody like in the modern nation state, or had it remained flexible and created on a case-to-case base? And if the late Hanafi shift was towards a fixed empire Sharia, what areas of it were codified? Thank you.
This is a very good question. I think the observation that Islamic law has always operated, again, has always operated in the context of empires and imperial governance and Muslim dynasties is a very good observation. Look, the moment in which the modern nation state tried to codify law and completely. So look, until the very late 19th century, the issue was not really, even among Muslim jurists, the issue is not about that the state is now codifying commercial law, or now the state is codifying even criminal law. The problem was, especially in the first half of the 20th century, like the projects of codification in Egypt, specifically under Sanhuri and so on and so forth, they thought codification going to be, again, especially after World War I and the loss of the Ottomans, what the idea was that codification will unify the nation under one single code. So codification was not just a template for legal technique. That was, oh, we need to unify the nation, and codification will allow that because France and Italy used to do that. That used to be the argument. The second point is that for them, legislation has always been connected to the idea of sovereignty. Oh, the idea for them then was, oh, if we'd like to be in control of our destiny, whatever, we need to be able to legislate. And legislation has always been connected in their own writings to the idea of sovereignty too. So to be able to deploy sovereign authority by the state and be able to unify the country, we have to have civil law like France and Italy and so on and so forth. And this was the argument that put in that direction. It's only until 1940s when Islamic law, again, person status law that is all kind of carved as a space by itself, was also completely incorporated into this. So even Islamic law, on that sphere that has to be only in family law, nationalists did not saw a future for Islamic law outside of civil law. They even did not see a future for Jewish courts. They had no future for even Christian tribunals outside of the state courts. For them, legal modernity meant state control over these domains. That's, I think, some of the struggles that we see today. For example, in the last few weeks, if you're following the kind of, I can speak about Egypt because I'm more familiar with it, they have a new person status law. Again, the state every 15 years went to update the law, they do whatever they want, get a couple shiuch, say it's great, and move on, it's maslaha and things like that. That's the situation that we find ourselves in. So I completely agree with you of how these things function in the modern context versus of how a context of empire has to function is a very diverse society, linguistically, religiously, and otherwise. That used to be the reality. And again, the kind of the other thing I would say is that that was not necessarily inevitable. So in the sense that we find today inside a state like Israel, for example, Jordan, for example, in which Sharia courts operating perfectly because they took on the Ottoman structure, they allowed Jewish courts to exist, they allowed Islamic courts to exist. And you know what? Look, Look up Islamic courts in Haifa, for example, and look how this guy's actually writing opinions. So you're right. Civil law, I think I have an article come out soon. I'm not going to say that now. It's called How Civil Law Ended Legal Pluralism. Exactly making this argument. Islamic law fits nicely in the context of common law. That's why I think Muslims thrive in a common law jurisdictions, legally and otherwise, rather than civil law strictures. Anyway, so I think I'm going to stop there, and thank you for questions.
We'll take the last comment before we'll hand over to Yakoob to summarize it. Yeah. Question by Mansoor: how much of late Hanafism, so I'm just trying to read this comment, how much of late Hanafism has impacted modern Islamic law today, whether it's in Egypt or Syria or in India or any of the Hanafi dominated lands?
So late Hanafism as an empirical matter, as a historical matter, we can prove beyond doubt that the most of the Majalla articles has been completely influenced by late Hanafi synthesis on so many issues. In terms of family law and otherwise, this is much more difficult, because that's, again, family law in the family is one of the most regulated, one of the most kind of issues in which the state take an active part to completely reshape and this deconstruct Muslim families through using the function of law. So there, the situation is just over the place. Really, what the state thinks is great is great. What thinks is not great is not great. To give you an example, very quickly, look at the custody law in Egypt today. Completely difficult to justify in any Islamic grounds. I always tell Egyptians, please adopt American law when it comes to custody. Is more Islamically oriented and Sharia compliant than what we have in Egypt, because it's not balanced. It's in one direction, and basically it's completely unfair to the man, to the husband. He actually denied any sort of custody over the child until the children reach the age of 15. So it's basically the complete adult life of a child, and then suddenly we speak about Islamic law. Well, I think it's difficult to maintain.
Okay.
Thank you. Because of time, we've only got 5 minutes left. I know you've got a class straight away. I'll hand it over to Dr. Yakoob and Dr.
Okay,
Samy.
so I'm not going to take up too much of Dr. Samy Ayoub's time, because I know we all need a bit of breather before we move into the next phase of another class. So I'm just going to say thank you very much, Dr. Samy Ayoub, for giving us your time. One of the things that I want to stress to everyone that is here today is, and this point where I've used the term collective amnesia, and Dr. Samy Ayoub has made this a historical disconnect, which is that many of the students who are studying Islamic law, Sharia, and so forth, that the studying of history is important. To look back in time, to look at this period in the Ottoman period is exceptionally important, because there seems to be a disconnect of the 19th century in regards to late Ottoman history. And that's to the detriment of all of those students who are studying right now. And so it's unfortunate that these studies are only taking place within the Western academic circles or in Turkey, and not in some of the seminaries. So I really encourage all of you here today to sort of invest in that. And I'm really grateful for Dr. Samy Ayoub for giving us his time. There's a last comment you want to make, feel free to do so. But from our perspective, thank you very much. And inshallah, we'll see you soon.
Dr. Samy, final thoughts?
Thanks so much for the invitation and the wonderful conversation. Please, if you have any other kind of questions, do reach out to me directly. If you happen to be in Istanbul during the summer, I'm most likely going to be there. Otherwise, thank you so much.
Can you travel? Travel from Texas?
Well, I think they will allow us to travel. It'll be fun.
Fantastic, mashallah.
Next week, we've got Dr. Osama Makdisi. So remember, next week we'll be
Dr. Makdisi next week. We're going to be talking about coexistence, inshallah. Okay, so thank you so much. Folks, just leave your email address if you want to get a copy, if you're not on our mailing list. Otherwise, we'll post it up on our YouTube channel if you didn't get to see the beginning or so. But we hope to have you back, Dr. Samy, again, inshallah, soon. Take care. Wassalamu alaikum wa rahmatullahi wa barakatuh.